Member for St. James West Central and newly minted Minister of Legal and Constitutional Affairs to address this Honorable House. May I please, Your Honor.
I join with us all in welcoming the newly minted, as the House Leader said, Minister of Constitutional and Legal Affairs to make her presentation to this House. Mrs. Marlene,
Madam Speaker, although this is my 7th consecutive contribution to these sectoral debates, it is my maiden as Minister. My deep gratitude for the Prime Minister's vote of confidence, which elevated me to his cabinet with full portfolio responsibility, takes second place to the commendation I must pay him for the bold step he took to establish this Ministry of Legal and Constitutional Affairs, to bring unprecedented, focused attention to the government's legislative and constitutional reform aspirations. It is no secret, Madam Speaker, that I have a sacred passion for the law and an abiding interest in the subjects of the portfolio, even though, of course, I'm always prepared to serve wherever I best add value to my team. All of us who serve the public, especially from elected political offices, bank on the support and kind understanding of our constituents, colleagues, friends, and families. Because, Madam Speaker, I think it's no exaggeration to say that life in representational politics is hellacious. As such, I acknowledge with
members, just
gratitude.
a moment. Members, there's a heavy murmur, and the Minister is making her presentation. And I really think out of courtesy, we should allow her to be heard. Please.
Thank you, Madam Minister. As I was saying, all of us who serve the public, especially from elected political office, bank on the support and kind understanding of our constituents, colleagues, friends, and families, because it is no exaggeration to say that life in representational politics is hellacious. As such, I acknowledge with profound gratitude the many, especially my family and close circle of friends, who have helped and held me along the way, who have stood and continue to stand in the gap with me. Although it is not possible in the context of this presentation to name them all, you will understand if I single out my husband, the Honourable Justice Ian Forte. Madam Speaker, I cannot thank him enough for his love, support, and wise counsel. May he always know how much I truly love, admire, and respect him. I should also like to once again place on record my thanks to the team at the Attorney General's chambers, and to wish my successor in the Office of Attorney General, Dr. Derek McCoy, Queen's Counsel, a satisfying tenure. I remain grateful for the cooperation and support of the CADOF professional, civil, and public servants, fellow parliamentarians on both sides of the aisles, the parliamentary staff, and the ministers of government, in particular, the Honourable Dr. Horace Chang, Deputy Prime Minister and Minister of National Security, and the Honourable Delroy Chuck, Minister of Justice, with whom I continue to work closely and have always enjoyed a collegial relationship. Very special thanks, Madam Speaker, to my Secretary, Personal Assistant, Mr. Desmond A. Smith, and the close protection officers assigned to me, Corporal Shard Walters and Constable Edwin Kalu Jr., who often go beyond the call of duty. Madam Speaker, permit me to use this occasion to pay homage to my St. James West Central constituents as their duly elected representative in this honorable House. I should also like to acknowledge my office staff, including the CDF officer, Mr. Gregory Brissett, Constituency Secretary, Ms. Ava Gordon, Divisional Secretary, Ms. Angela Braham, the groundsman, Mr. Dwight Livingston, and the executive and management teams, including Councillor Dwight Crawford of the Spring Garden Division, Divisional Chair and Coordinator, Mrs. Rena Forbes, and Mr. Brian Hosu of the Mount Salem and Granville Divisions. And Madam Speaker, all the members of my management team, Messieurs Robin and Robert Russell, Dale Della Penna, Neil Baugh, and Miss Anne-Marie Tree. And Madam Speaker, I warmly greet all who are tuned in, watching and listening attentively to this address, including Councillor Troop and Councillor Kerry Thomas. Madam Speaker, our constituents are depending on us. Our constituents are depending on us to do right by them. Many have no privilege of office or any connection in high places. They need every part of government with which they interact to be more responsive, more efficient, and more accountable to them. We must therefore be relentless in our representation to have a strong and effective government to better serve them. Because, Madam Speaker, a weak and ineffective government is easily manipulated to produce unjust and corrupt outcomes that harm the people. Doing right by the people includes exercising greater care in how we manage campaigns when running for office. So often, we give the impression that we can do all things to all men and end up relieving others of their share of responsibility for the work. Unrealistic expectations are set, which cannot be met, leading to disappointment and distrust. Furthermore, we make the grave mistake of thinking that it is okay to engage in the most despicable acts and illicit activities on the campaign trail, but then expect integrity in the affairs of government when those who so engaged are put in charge of any part of government. My generation of political leaders must consciously eschew the evil practices done in the name of partisan politics, and then deliberately practice politics in a more constructive and indubitable manner. Madam Speaker, I take responsibility. I take the responsibility of my constituents very seriously, and I believe all of us do. My style of politics is not the up-in-your-face, rambunctious style. Not that anything is wrong with that. My preference is to, without fanfare, go about to the business of the people, spending time to get first-hand knowledge on what is happening on the ground, and speaking with constituents directly. Madam Speaker, it truly, truly irks me when I make the necessary representation to have issues addressed, and then the appropriate part of government with responsibility is unresponsive or delivers substandardly. We desperately need all parts of government to work together, with each part doing its fair share of the work. What happens in one part impacts what happens in other parts. While the MP is often the first point of contact with government for many constituents, it is vitally important that they understand that government is much bigger than the political directorate. The belief that the MP has the power and authority to take action to fix whatever is wrong in government is a mistaken one. Because government, Madam Speaker, is not a one-man show. The ministries, departments, and agencies are staffed by administrative, professional, technical, and other officials. We sometimes forget that although the boundary lines between the political directorate on the one hand and the civil and public service on the other hand sometimes blur, they are in fact sharply drawn in many areas. Madam Speaker, I have always maintained that the face of government that we see at any given time is the face of the individual or the institution we interact with. In our quest for improved governance, the relevant office holders whose conduct is in question is to be held to account. Roles and functions are formally and legally assigned to various offices across government. It cannot be overemphasized that the place to spot a fault is where it occurs. I said it last year, and I'm repeating it this year. The persistent failure to hold individuals to account, or to do so in a timely manner, and the tendency to broad brush an entire cohort have tarnished individuals, have tarnished institutions, and have compromised systems. Madam Speaker, the complex legal and political governance issues I deal with on a daily basis expose the underbelly of the society and bring the inner workings of government into sharp focus. How Jamaica responded to the COVID-19 pandemic, for example, can be a most useful case study. While addressing these complex legal and political governance issues, have served to deepen my working knowledge of all areas of the law, especially constitutional and administrative law. They have also highlighted things taken for granted by state agents in the performance of duties and the general exercise of leadership at various levels. These things not only expose the state to liability, but they also undermine confidence in the machinery of government and decrease government's effectiveness. Madam Speaker, on the matter of constitutional law, I must mention in passing how I welcome the clarity provided by the Judicial Committee of the Privy Council on the vexed question of mandatory minimum sentences and on the separation of powers doctrine in its judgment given on 16 May 2022 in the case of J. Chandler, and the state Trinidad and Tobago. The principal constitutional question raised in that appeal was whether the mandatory death penalty for murder was contrary to the Constitution of Trinidad and Tobago, adopted in 1976 when the state became a republic. In reiterating the law applicable to constitutions on the Westminster model, at paragraph 79 of the judgment, the following appears. Turning to the role of the legislature, Lord Diplock stated in Hines against the Queen, that's a case out of Jamaica, in the exercise of legislative power, Parliament may, if it thinks fit, prescribes a fixed punishment to be inflicted on all offenders found guilty of a defined offense, as, for example, capital punishment for the crime of murder, or it may prescribe a range of punishments up to a maximum in severity, either with or without a minimum, leaving it to the court by which the individual is tried to determine what punishment falling within the range prescribed by Parliament is appropriate in the particular circumstances of the case. Madam Speaker, I highlight this because the issue of the mandatory minimum penalty, which we have provided for in the new firearms law, has been the subject of very heated debate in the Parliament, understandably so. And many have argued, questioned the constitutionality of the provision. And lo and behold, before we have even passed the law, our final court has reminded that it is indeed quite permissible. And of much more significance for me Madam Speaker. Our final court in the same Chandler case reminded that the separation of powers also works to prevent judges from arrogating to themselves powers vested in another branch of government. You know, sometimes we think about it as the parliament or the executive intruding on the legislature, but a poignant reminder that it also appears to the judicial branch. Madam Speaker, my almost 6 years tenure as Attorney General, atop my role as Member of Parliament, gave me new insights into how the law impacts the everyday life of the people. Early in the day, I began to closely examine the relationship between the rule of law and sustainable development, from the perspective of the law as a development end, as well as a means to sustainable development. Over the years, I've also been analyzing this relationship through the lens of the three rule of law components: legal frameworks, institutional capacity, and legal empowerment. In developing legal frameworks, great care is required at each stage of the process. The spirit of the law, as well as the letter of the law, must be clear to avoid unintended consequences in use and interpretation of the law. Madam Speaker, permit me to now direct attention to the portfolio work of the ministry. I gather there is much anticipation across government and in the wider society, as well as in the diaspora, of what I may be announcing on the constitutional reform front. If I had the skills of some who presented before me, I would cut a tune. But, you know, I know my limitations. No. I will do what I can a little later on. I'll do what I can a little later on. But let me just tell you, Zion train is coming our way. All right. Zion train is coming our way. Get on board. Get on board, because Zion train is coming our way. Metaphorically speaking, of course. Before dealing with the matter of constitutional reform, I will first report on the work done in the other portfolio areas of the ministry for the reporting period. In doing so, I should like to firstly acknowledge my permanent secretary, Mr. Wayne O. Robertson, who is here in the House, Madam Speaker. P.S. Robertson has been working assiduously to set up the ministry. I have to say a big thank you to the Office of the Prime Minister, where we are currently housed, and the Ministry of Justice, with whom we share corporate services. I second what the Prime Minister said when he acknowledged Permanent Secretary Mrs. Audrey Sewell of the Office of the Prime Minister and the Ministry of Economic Growth and Job Creation as one of the most effective, knowledgeable, and hardworking permanent secretaries. Mrs. Sewell has been very helpful to us, and I know that Mr. Robertson has learned much from her. My every interaction with her has been pleasant, professional, and productive. Madam Speaker, in my maiden ministerial statement to this Honourable House on January 18, a week after this ministry was created, I advised that the portfolio has been assigned 4 subjects and 3 departments for a start. The subjects are legal reform, constitutional reform, legal education, which includes the Council of Legal Education's Norman Manley Law School, now under the principalship of Ms. Carol Aino. And fourthly, the protection of human rights, which involves interfacing with the Office of the Public Defender. The departments are the Office of the Parliamentary Counsel, headed by the Chief Parliamentary Counsel, Ms. Judith Grant, the Legal Reform Department, headed by Ms. Nadine Wilkins, and the Law Reform Secretariat, headed by Mrs. Julia Gowie Williams. Madam Speaker, I use this occasion to thank the outgoing public defender, Mrs. Arlene Harrison Henry, for her service as head of this important commission of Parliament, and to also commend the staff of the office for their work on behalf of the people of Jamaica. I will address the outstanding matter of the proposed National Human Rights Institute at a later date. I now turn to the Norman Manley Law School. From the time of my appointment as the Attorney General in 2016 until I demitted that office in January of this year, I served as a member of the Council of Legal Education, pursuant to the provisions of the Council of Legal Education Act, which provides for the agreement establishing the Council of Legal Education to have the force of law in Jamaica, and which, among other things, mandates the Attorney General's membership on Council. Madam Speaker, I got a first-hand understanding of the operations of the Council and learned that I was an exception to my predecessors in office based on my regular attendance at Council meetings and my participation in its various other activities. Now, as the Minister for the time being charged with the responsibility of legal education, I'm pleased to continue my relationship with the Council of Legal Education, albeit in a different capacity. And I'm also pleased to provide a brief report on the Norman Manley Law School, which is located on the Mona campus of the University of the West Indies here in Jamaica. The latest academic report on the school's education results reveal in broad terms that 85% of students routinely graduate within the 2 years of the legal education certificate program. 95% of students routinely graduate within 3 years, which means that 10% of students repeat one of the years in the program. Madam Speaker, it gives me great pleasure to also extend, albeit somewhat belatedly, heartiest congratulations to the Norman Manley Law School team, who now proudly holds the winning trophy for the Caribbean Court of Justice mooting competition in its 12th year after defeating the Hugh Wooding Law School at the first ever virtual meet. The Norman Manley Law School had previously won the competition in its inaugural year in 2009, and then in 2016, and again in 2018. As noted in the principal's report, mooting competitions are recognized as impressive vehicles for international and regional benchmarking of legal skills. As one judge of the court noted, in announcing the winner, there was a marked difference between students in the undergraduate program and those in the vocational program, thus underscoring the value added by the legal education program. Madam Speaker, it is noteworthy that altogether the 3 council schools have won the CCJ's competition in 11 of 12 years. The Norman Manley Law School also progressed to the advanced rounds of the Philip C. Jessup competition last month. This competition, the Philip C. Jessup Moot Court, is the most prestigious international law moot court in the world. Some here know it. On another occasion, I will address some issues that fall for consideration under this subject, including the challenges faced by graduates of the University of Technology and other non-UWI Bachelor of Laws degree holders, and the options to be considered to address these issues. I look forward to working with the Minister of Education to resolve the issues facing the students in the shortest possible time. Madam Speaker, I now turn to the Office of the Parliamentary Counsel. I'm pleased to inform this Honourable House that over the reporting period the OPC dispatched 179 complete drafts, with another 4 in progress on 73 bills. 16 of these bills were passed into law. I have set out in the written text those 16 bills passed into law. And I have also set out the details of the 73 bills by name and number of drafts per bill dispatched to the relevant portfolio ministries. When the presentation is distributed, you will see how the work has been allocated among the various ministries, Madam Speaker. You know, contrary to the impression formed by some that the Office of the Parliamentary Counsel is primarily responsible for delays in the legislative process and claims that bills are usually stuck there, the Chief Parliamentary Counsel and her team do deliver in a timely manner when drafting instructions are clear and complete and policy issues are settled. At the same time, it is very true that the office is under-resourced for the size of our government and the robust legislative response that is required in so many areas to address so many issues in the society. I turn to the Law Revision Secretariat. The core objects of the Law Revision Secretariat, the LRS, is to increase access to the laws through the annual publication of the revised pages of the Laws of Jamaica volumes and the facilitation of the publication of laws online. The ongoing task of consolidating the laws of Jamaica is usually done on a year-to-year basis. That is to say, there is a revision year, and it involves reviewing all of the new legislation that are in force up to the cut-off date. And that cut-off date is December 31st of each year. And then they are to be included in all acts passed and operationalized, and all subsidiary legislation promulgated, both being duly gazetted, to determine what changes to the revised laws of Jamaica have been activated by the new legislation. Madam Speaker, I just say to my fellow parliamentarians that although it sounds technical, it is important that every member of parliament understand what this means. It's not an area that is reserved only for the lawyers. We are the lawmakers, and we need to understand the context that we set for the nation. Madam Speaker, the Law Revision Act provides for the functions of law revision to be carried out by law commissioners. An assessment of how the Law Revision Secretariat has been functioning reveals that the current system may have to be reconceptualized, as the statute law commissioners are not now involved in the day-to-day task of law revision. Furthermore, the staff complement is not adequate to keep a pace with the volume and scope of work. The reclassification of posts to reflect the knowledge, competence level, and required skill sets to properly revise the law is still pending, even though a comprehensive strategic review was done. Madam Speaker, the entire system must be redesigned and appropriately resourced to make it fit for purpose.
Hear, hear.
To produce up-to-date and accurate legislative information online and elsewhere, we must also reduce the lag time between the enactment and inclusion in the revised laws of Jamaica. Right now, Madam Speaker, I take no pleasure in saying ministries do not have a compilation of ministerial orders, and legal officers do not know where to find the gazettes with them. The goal is to have a dedicated website where the acts passed by Parliament and the subsidiary legislation can be published and circulated in a searchable database, which also includes sunset legislation and repealed acts of Jamaica, as well as gazettes containing legal notices and other relevant matters. You know, Madam Speaker, I recall my days as a judge of the parish court, how I lamented that our law was not available in a more user-friendly manner. I thought then how convenient it would be to see not only the primary legislation, the Acts of Parliament, but also the relevant regulations in one place so that judges, lawyers, and others could easily access them. Later, as Attorney General, I decried the exclusion of the Memorandum of Objects and Reasons from prints after enactment, and I truly agonized when I had to look in so many different places to get a complete picture of the law, where regulations, including ministerial orders, were made under an act. Notwithstanding all of that, Madam Speaker, I'm pleased to report progress made on the work of law revision. Work commenced under the Ministry of Justice, and I assure everyone that the deficiencies identified will be addressed in due course. Madam Speaker, it gives me great pleasure to report that the Ministry of Legal and Constitutional Affairs has entered into a memorandum of understanding with the Jamaica Promotions Corporation, the JAMPRO, to introduce a comprehensive legal information portal. This project will be funded by the World Bank under Component 1 of the Foundations for Competitiveness and Growth projects. No longer will extensive time and effort be expended to identify gazette notices and laws. Once implemented, you will be able to get them right away. Madam Speaker, the Ministry intends to use the web portal to engage on law reform issues. This engagement will serve to inform both the public and the Ministry itself about the issues of concerns that are to be considered in the development of law reform proposals. The portal will also provide access to, among other things, the revised laws of Jamaica, and I'm talking about all editions from the 19th century to the present, the annual Acts of Jamaica from the 17th century to the present, the Jamaica Gazette publications, proclamations, rules and regulations, bills and acts, and the Gazette Extraordinary. I'm pleased to report that funding of the software and equipment, as well as technical expertise, have been secured from JAMPRO, and the project is expected to begin in 2023. At this time, material is being scanned and prepared for upload to the website when it is developed. The portal will include also the judgments of the court, what we call common lawmaking. Madam Speaker, the creation of a Jamaica Legal Information Portal is also complementary to the broader efforts to modernize Jamaica justice sector institutions and processes. The broad programs of justice reform and the renewed focus on updating the laws of Jamaica, in particular, align and is grounded in the high priority accorded by the Andrew Holness administration to the resolution of issues affecting access to justice and the rule of law. More importantly, Madam Speaker, the program also supports the economic imperatives of the government in terms of improving Jamaica's business environment and competitiveness. Improvements in the availability of legal information should therefore be assessed as complementary to and part and parcel of the broader framework of Jamaica's economic growth agenda. Madam Speaker, the Ministry of Justice had commenced the process of operationalizing a new legislative production management system, the LPMS, a few years ago. This system is a comprehensive, modern, computerized tool capable of managing the life cycle of legislative documents, from drafting to publishing. Once introduced, it will connect all government entities involved in the drafting and publication of legislation. This will redound to a more efficient legislative review process and reduction in the time, in the amount of paper used. Implementation of the system has been affected by delays, as many things have been with the pandemic and other things. After conducting a gap assessment, My ministry has determined that an information technology consultant with experience in SharePoint implementation is needed to assist us in implementing the system. The consultant is projected to commence work by September of this year and complete the assignment over a 9-month period. This would see the rollout of the system by June 2023, all things being equal. Madam Speaker, the preparation of materials for upload to the Jamaica Law's online website is in progress. The Law Revision Secretariat has completed and delivered revised laws for 3 legislative years, 2016, 2017, and 2018, during the reporting period of fiscal year 21-22, and has also completed and finalized update for the 2019 statutes. The next steps are the completion of typesetting and proofreading for 2019 subsidiary legislation and for legislative years 2020 and 2021. Actual update of the website is underway with upload of 2016 revised laws. We're talking about the statutes and the subsidiary legislation, now 50% complete, as 70 pieces of new and amended legislation have been uploaded. Madam Speaker, the Acts of Parliament 2001 and 2005 to 2020 have been uploaded, and 80% upload of the Jamaica Gazette 2001 to 2021 has been achieved in the reporting period. A digitization project to convert the index copies of the Jamaica Gazette, proclamation rules and regulations, and extraordinary from the hard to soft copy for the purposes of preservation, maximization of storage space, as well as the creation of digital content that can be eventually organized and made available online to the public is ongoing. The targets and achievements of the Secretariat over the reporting period are set out in 2 tables in the printed presentation. And when it is circulated, you can see the detail of the work done, target set, and what has been achieved quarter by quarter, Madam Speaker. I now turn to the Law Reform Department. The primary function of the Law Reform Department is to constantly review the laws and then propose to the policymakers laws that are to be passed, reviewed, updated, or even repealed. The continued relevance of older laws is to be assessed and checks made whether they have been superseded by other laws. I'm advised by the Director of Legal Reform that all 19th century law on our books are now being reviewed. And in this regard, like in other matters, unlike in other matters, where the role of the Director of Legal Reform is a reactionary one, it is the Director who determines priority. Yes. Since priority is not determined in a vacuum, though, the criteria which guide the order of review must be carefully considered and even re-examined, if need be, having regard to wider governance issues. Although there is currently no requirement for policy documents for law to be submitted to the LRD, but properly ought to be submitted, the LRD does review cabinet submissions and review draft bills. This allows for a determination of whether a proposal for new law is already covered by existing law, or if an existing law goes far enough, and also the role of other laws in achieving the desired goals. While it is the Attorney General that has ultimate responsibility for advising on the constitutionality of any proposal, the Law Reform Division also opines on the matter and attends to the Legislation Committee of the Cabinet where necessary, and provides technical support to the Joint Select Committee of the Parliament. Although, Madam Speaker, the LRD is challenged by paucity of resources, which impacts its response time, I'm confident that we will overcome when the wider public sector reforms that are now underway are implemented, especially the revised remuneration level to enable experienced staff to be recruited and/or retained. Notwithstanding all of the challenges, Madam Speaker, I'm pleased to say that the Law Reform Department is poised to play a more pivotal role in the conceptualization of legislative policy and the development of preliminary documents, including assisting with the drafting of cabinet submissions. I believe that a certain type of synergy is required among the different players who have a critical role in the lawmaking process if we are to achieve the reform goals timelessly. Consequently, I have shared some perspectives with the Prime Minister as he gives further consideration to the arrangement of his government for greater efficiency in the working relationships among ministries, departments, agencies, and in particular among this Ministry of Legal and Constitutional Affairs, the Ministry of Justice, and the Office of Attorney General, as well as the Parliament. In the meantime, I place before the Cabinet for its approval a proposal that will formalize arrangements across all of government on how to improve the flow of legislative work. I now turn to inter-ministry legislative collaboration. Madam Speaker, one of the strategic priorities of this ministry is to address the slow pace of legislative reform in the public sector by strengthening inter-ministry collaboration. The aim is to improve operational efficiency, speed, and the quality of legislation promulgated, because the legislative process has been affected by delays, culminating in critical pieces of legislation neither being amended, repealed, and replaced, nor developed and subsequently passed in a timely manner. The situation has been exacerbated by the lack of adequate human resources in some ministries, coupled with the crafting of ambitious legislative targets prior to the start of each financial year. Some targets, which are encompassed in strategic and operational plans, the annual legislation program, and the throne speech, are not accorded priority and the concomitant dedication and focus by some entities. Madam Speaker, this Ministry of Legal and Constitutional Affairs cross-cuts all of government and, in fact, dips into other ministries with a supervisory role on legislative matters. To facilitate this work, I am pleased to inform the Honourable House that Cabinet has granted approval for the establishment of legislative teams in each ministry to include the relevant policy officers, the relevant legal officers, and the relevant senior officers at the level of Chief Technical Director, Principal Director, or Senior Director. And they would be responsible, who would be responsible for working closely with the policy and legal officers to provide oversight for each ministry's legislative program as part of my ministry's work to strengthen inter-ministry collaboration and advance the government's legislative program. Therefore, we will be dealing with a focal point in each ministry, and internally they would have the responsibility of coordinating, regardless of the subject matter, regardless of the department, regardless of the entity, and then the Ministry of Legal Affairs interface there, provides guidance, technical assistance, etc. Mind you, Madam Speaker, this submission was debated and discussed in detail as ministers inquired exactly what is to be done. Since it's not the norm for another ministry to reach into
Have you heard about this
discuss in detail as ministers inquired exactly what is to be done, since it's not the norm for another ministry to reach into other of legal education will transcend the provision of monthly subvention to the Norman Manley Law School to further include implementation of a robust program to augment technocrats' knowledge and awareness of the law, which govern the operations of their entities, as I said before, the legislative review process and their role in the process. The Ministry recognizes the need to improve knowledge and understanding of legislation in each ministry's portfolio. Enhanced knowledge and understanding will reduce, if not prevent, the government's exposure to court actions and ultimately liability. It will also help improve confidence and integrity in government. And I so look forward with much eagerness to implementing this public education program on the laws of Jamaica. The purpose of the program is to educate the technocrats. I say it and I say it again. I say it and I say it again because it is so important, Madam Speaker, so important. You know, the ministry has really hit the ground running. We are motivated and we are poised to achieve the results once we get the cooperation of the rest of government and the resources from the Ministry of Finance and the Public Service. Madam Speaker, before I turn to the final area of my presentation on constitutional reform, I should like to advise the Honourable House that a new Bail Act is coming. I wanted to table it today, but we are revising the wordings of some clauses. I will not say much more at this stage, Madam Speaker, except, and I want you to hear me well. I want you to hear me. I want everybody to hear me well. Madam Speaker, if you're on murder charge, you cannot be at large. If you're on gun charge, you cannot be at large. The Bail Act will come shortly. Madam Speaker, I now turn to that subject matter of constitutional reform. Madam Speaker, the continued symbolic presence of the British Crown in the constitutional makeup of our state and other Commonwealth Caribbean states has been repeatedly placed on reform agendas here and across the region. With Little England officially severing ties from Queen Elizabeth, Big England, and establishing the Republic of Barbados in 2021, and Prime Minister Holness's announcement of his government's intention to move on from a constitutional monarchy, eyes are now focused on the remaining Commonwealth Caribbean realms to see who will take the next step when. The mandate of this new Ministry of Legal and Constitutional Affairs includes spearheading the most meaningful and comprehensive post-independence constitutional reform work to be undertaken in our nation. The goal, Honourable Leader of Opposition, is to ultimately produce a new constitution enacted by the Parliament of Jamaica, establishing the Republic of Jamaica as a parliamentary republic, replacing the constitutional monarchy, and affirming our self-determination and cultural heritage. Madam Speaker, the work will be done in stages, but it has formally commenced. Just wait on. It has formally commenced. Before I get to timelines, I should assist in providing clarity on aspects of our constitutional history, because I hear so much being said about what we have, what we don't have, how we got it. I note misunderstanding in some quarters about how we got the Constitution and what may have been what will be involved in changing it. Some believe that, like Barbados, it could have happened overnight and in a certain time frame. And some statements made in the media and on political platform about the conversations have not quite been accurate. Madam Speaker, for all practical purposes, the constitutional experts tell us that the history of the constitutional laws of Jamaica begins with the 1655 acquisition of the island by the British. The constitutional status of a British colony depended on whether it by Spain to England in the 1670 Treaty of Madrid between England and Spain, and it ended the war which began in 1654 in the Caribbean, in which England conquered Jamaica. The title of the Spanish crown had itself been the subject of legal dispute, and it is doubtful whether on restoration the king could adopt and ratify an act of illegal warfare. Furthermore, the Spanish administrators had negotiated an agreement with the English invaders by which the Spanish were permitted to withdraw freely from the island, leaving no settlement or administrative structure. Ever wonder why we don't have any institutions from the Spanish period? From the beginning, therefore, Jamaica came to be treated as a settled colony, but the peculiar circumstances, they say, sowed seeds of legal problems of far-reaching constitutional importance. Early on, Madam Speaker, Jamaica suffered a military government administered by the commanders of the invading British forces. Edward Doyle was an officer of the original 1655 expedition. He survived his superiors, He continued to administer the affairs of the island under military jurisdiction, assisted by Executive Council of Officers because of the political uncertainties in England, until he was formally confirmed in the position of governor in 1661. As the first governor, he did very little to develop the civil institutions. And I'm citing this for a reason. When Lord Windsor replaced Doyle and became the second governor in 1662, the Royal Commission and instructions to him empowered him to govern in accordance with all such laws, customs, and institutions as are exercised and settled in the other colonies and plantations, or such others as shall, upon mature advice and consideration, be necessary and proper for the good government and security of our said island of Jamaica, the said island adjacent, provided that they were not repugnant to the laws of England, but agreeing thereto as near as conditions of affairs will permit. Governor Windsor was also empowered to call assemblies together and to make eminently necessary laws for 2 years, unless they were conferred by the Crown, to levy monies, provided that they were not repugnant to the law of England. Listen to this. The Assembly, which met in 1664, immediately gave notice of the constitutional doctrine to which it would subscribe. One of its first enactment was a law declaring that the laws of England were in force in Jamaica. An early report of a reply from Governor Modiford had this to say: right reason, which in the common law of England is esteemed and of force amongst us, together with Magna Carta and the ancient statutes of England, so far as practicable. Madam Speaker, that is a very short and abridged story of how the laws of England became the laws of Jamaica. The early constitutional history is to a large extent concerned with the struggle of the inhabitants under an early form of representative government to assert claims to the privileges and rights of the English settlers. That, Madam Speaker, is why the records show us aspiring for certain things. Let me now turn specifically to the making of the Constitution. Critics say, though independence was supposed to mark a definite break from the colonial past, paradoxically, it seemed obvious to the Constitution makers that the Constitution ought to be, as far as possible, continuous with the past. They also say that the People's National Party nationalism more or less surrendered to Anglophilism of the class from which it came, and more generally the society it hoped to reform, because at no time did they seek to assess critically the applicability of British institutions to the Jamaican context. On the contrary, the colonial connection should go in order that the party might lead the way to bringing British political culture to Jamaica. In the defining years, it is said that the People's National, in the defining years, I'm coming to tell you, that's not the end of the story. Let's not quarrel. In the defining years, it is said that the People's National Party, I don't understand, just the mention of parties wake up everybody. Interesting. Madam Speaker, it is said that in the defining years, the People's National Party allowed more importance to the fact that all our ideas about politics come from Britain. All the institutions to which we are accustomed are British. And this is actually found in the PNP pamphlet of Join the Party around 1939. That's not the end of the story. I'm setting it out for a reason. Don't get impatient. Don't get impatient. To that extent, the advocacy was for the type of self-government which was democratic and fundamentally British. Ladies and gentlemen, this is what the records reveal. I'm not making it up, and you can check it. But I know not everybody will dig into the record. Absolutely. Wait for the rest of the story. So hear this, Member Jackson, through you, Madam Speaker. Norman Manley, described as the father of Jamaican nationalism, said he made no apology for the fact that he did not attempt to embark on any original or any novel exercise for constitution making, but deliberately opted for what they were familiar with. The system of parliamentary government, which over the years, listen man, Chairman, the system of parliamentary government which over the centuries had been evolved by the British people, who display the most unique genius of any people in history for devising a form of government acceptable to the people. It was a system they understood, said he, and which we had been operating for many years with sense. He felt it was a system which was consistent with the sort of ideals we had in this country, and so it was not difficult to decide to follow that familiar system with those modifications. They thought the circumstances of, invite you to look at the Jamaica Hansard, 1961 to 62, at page 719. It doesn't stop there. It doesn't stop there. The report, Madam Speaker. You know, I hear so many things about how we got what we got. I thought it very important to just check the records, dig through the files, and just help to inform this Honourable House and those listening. The report of the Joint Committee records at page 18 that a considerable body of opinion which appeared before the committee favoured a non-monarchical head of state. Most of the submissions in this regard were based on the assumption that independence had to involve some identifiable break with the past for it to become an extraordinary national experience. The proposal for a constitution whereby Jamaica would become a republic within the Commonwealth with a ceremonial president as head of state, with the importance of the symbolic difference that the head of state should derive the powers under the Constitution and not be regarded as the representative of the Queen, was rejected without the Joint Committee ever given a full explanation. The report, which was unanimously adopted by the legislature, merely stated that the Constitution provided for Jamaica's becoming a constitutional monarchy, while acknowledging that there were many proposals that Jamaica should become a republic, with some favouring a republic within the Commonwealth of Nations and a small number favouring a republic outside of the Commonwealth. The committee took the view that in substance there did not appear to be any fundamental difference between its preferred form, constitutional monarchy, and the proposal for a ceremonial presidency. So, Madam Speaker, at the court at Buckingham Palace on the 23rd day of July, 1962, the Queen Most Excellent Majesty in Council, Her Majesty, by virtue and in exercise of the powers in that behalf by subsection 1 of Section 5 of the West Indies Act, was pleased with and by the advice of Her Majesty's Council to order and thereby promulgated an order cited as the Jamaica Constitution Order in Council 1962. It was reportedly signed by one W.G. Agnew. The Jamaica Constitution Order in Council 1962 provided that the orders in Council specified in the first schedule, that is, the Jamaica Constitution Order in Council 1959, the Jamaica Constitution Amendment Order in Council 1959, the Constitutional Amendment Order in Council 1961, referred to as the existing orders, were revoked. Notwithstanding the revocation, the Public Service Regulation 1961, we still have it. The Judicial Service Regulations 1961, we still have it. The Police Service Regulations 1961, we still have it. The Jamaica Constitution Retirement of Entitled Officers Regulations 1961, some amendments have been made, we still have it, which were made under them, and all amendments thereto were to continue in force, subject to such adaptations and modifications made. All laws which were in force in Jamaica immediately before the appointed date were to also continue in force. Madam Speaker, the Constitution of Jamaica was set out in the second schedule of this Jamaica Constitution Order in Council 1962, with the appointed date of the 6th day of August 1962. You know, Madam Speaker, we may continue to engage in spirited debate on why we got what we got, but I think it's important to say that it's been a long time coming, but the change is going to come. It's going to come. So before I turn, I can't sing. If I could, I would mellow the tune. Before turning to the why, the what, and the when of the constitutional work, permit me to just provide some further information on how we got the Independence Constitution. It is important for the work to come. On the 19th of July, 1962, an act to make provision for and in connection with the attainment by Jamaica of fully responsible status within the Commonwealth was passed by the English Parliament. Simultaneously, on the said 19th July 1962, the legislature of Jamaica passed the Jamaica Independence Act as an act to make provision for and in connection with the attainment of fully responsible status within the Commonwealth. These are 10 and 11 Elizabeth II at chapter 40. Madam Speaker, no, you know, it's really good to do research from time to time. And when I said earlier that the work that I have to deal with on a daily basis really deepen my knowledge on so many areas. So this act, the Jamaica Independence Act, it provided that as from the 6th day of August, 1962, we all know what that day is, but in that act it's referred to as the appointed day. Her Majesty's government in the United Kingdom shall have no responsibility for the government of Jamaica, and no act of Parliament of the United Kingdom passed on or after the appointed date shall extend or be deemed to extend to Jamaica as part of the law thereof. And from that day, the provisions of the first schedule to the Act shall have effect with respect to the legislative powers of Jamaica. And those powers still remain. The Jamaica Independence Act is deeply entrenched in our Constitution. But here it is, Madam Speaker. Among other things, the first schedule provides that the Colonial Laws, the Validity Act of 1865, shall not apply to any law made on or after August 6, 1962 by the legislature of Jamaica. No law and no provision of any law made on or after August 6 by the legislature of Jamaica shall be void or inoperative on the ground that it is repugnant to the law of England or to the provisions of any act of the Parliament of the United Kingdom, including the same Jamaica Independence Act which was promulgated by the United Kingdom, and to any order, rule, or regulation. But you know, there is another power that has been hiding in this act. Deputy Prime Minister, I think you may be interested in this one. The Jamaica Independence Act provides that the legislature of Jamaica shall have full powers to make laws having extraterritorial operation.
What? What does that mean? Tell us what it means.
Believe it or not.
Tell us what it means.
This is in our Constitution. Extraterritorial operation. Because I'm a little surprised, not that I didn't know it, you know, I knew it. My expression of surprise is based on so many things I've heard about what we can and cannot do as a parliament, particularly in addressing organized crime, particularly in addressing, you know, money laundering, countering financing of terrorism. And who says what is even more surprising. And that is why I say perhaps they are unaware that this parliament's legislative power extends extraterritorially. And we can't change this without a referendum. And I don't think we would ever want to change this because it's the Independence Act. So, nothing in the Act shall confer on the legislature of Jamaica any power to repeal, amend, or modify the constitutional provisions otherwise than in such manner as may be provided for in those provisions. Constitutional amendment provisions. And when the law speaks of the constitutional amendment provisions, it means the Independence Act, any order in council made before August 6, 1962, any law or instrument made under a law of the legislature of Jamaica made on or after August 6, 1962, which modifies, amends, or enacts, reenacts with or without amendment or modification, or makes different provision of any such law or order in council or any such law or instrument previously made. And by the way, what is set out here is the same definition of amend in the Constitution, which we will have to contend with, even if you're tidying up. The audience is not just those who are present in Parliament. We could have done much better, many argue, with the powers that were given to us on independence. In fact, like I say, you know, some people express surprise when they are reminded or told for the first time that the Parliament of Jamaica can pass laws having extraterritorial operation. Be that as it may, I think that there are many lessons to learn at the juncture at which we are. So, Madam Speaker, this now leads me to the crux of the matter. Our Constitution has three types of provisions. We've said it before: ordinary provisions, ordinarily entrenched provisions, and deeply entrenched provisions. And the procedure for amendment is set out in the Constitution. For the ordinary provisions, a majority of all members of both houses is required, not just the majority of those present and voting, as is required for ordinary laws. The deeply entrenched provisions for the vote, we require 2/3 in both houses, and we know that it is not possible to secure 2/3 vote in the Senate without cooperation across the aisles. And then any bill which is amending a provision which requires this vote has a delay period that is built in. 3 months at the start, 3 months at the end. So alone you have 6 months of dead time. The law also provides that for those provisions which require the 2/3 vote but do not require a referendum, if the cooperation of the Senate is not received, it can go to the people, and a 3/5 vote would suffice to approve. And then we have the deeply entrenched provisions, which we will be dealing with. In fact, we'll be dealing with everything. And these provisions, which include the provisions relating to our Parliament and the Queen as our head of state, these provisions are deeply entrenched. And we need the vote of the people. After the bill has gone through the House with the delay time, and the time supposedly is to be used for proper consideration, to inform the people, get them on board, explain in details to them what it is that they will be required to do, to have parliamentarians think long and hard about the next steps. We will have to go to the people. You know, Madam Speaker, I've been looking at Jamaica's attitude to referendum, because we will have to go there. We are going there, and we're going there hopefully by the time the next election comes around, unless more pressing matters or something else overtake. But that is the aim. Madam Speaker, you know, we have quite a bit of work ahead of us to do. Based on the amendment provisions of the Constitution, the reform work to be done in order to achieve the goals of producing a new constitution passed by the Parliament of Jamaica will therefore require cooperation between the government and the parliamentary opposition, as well as the seal of the people. As I say, it is a sine qua non. The process, therefore, must be inclusive and reflective of representativeness and broad-based performance. Madam Speaker, there are important substantive and procedural issues to be resolved to ensure a smooth transition to a republic. I've looked at the recommendations that have been made, and each recommendation that I have looked at will require careful thought as well as substantial resources to implement them successfully. To further the process of moving from recommendations to action, I propose to appoint a constitutional reform committee to include representatives from the government, parliamentary opposition, relevant experts, and the wider society. Madam Speaker, time did not allow me to have a follow-up conversation, exchange, outside of this medium with the leader of the opposition. And I say it is not my intention to have the discussion that should be had based on our exchanges in this forum, but I do believe that some of what I will say will allay the concerns that you have expressed. So I have written to the leader of the opposition with a request for him to name 2 members of the parliamentary opposition to this committee, which is now being constituted. I have set out the work to be done by the committee in very broad terms, specifying, among other things, that it will involve at this stage the conduct of a thorough and comprehensive review of the 1962 Constitution, including the 2011 Charter of Fundamental Rights and Freedoms, as well as recommendations for reform made through the various constitutional reform commissions and committees in the past. Ultimately, to implement an ambitious reform agenda settled by consensus. And I've said that the ultimate goal is a constitution enacted by the Parliament of Jamaica. It's not just amending what is contained at the second schedule of the Order in Council. No. Madam Speaker, the leader responded with expressions of concerns, and it is obvious to me that he thinks that the approach is meant to delay the matter. Yes, that is what I sensed from your response. I sense that you are of the view, Leader of Opposition, that the relevant parameters, in fact you have said so, for Jamaica to become a republic have already been agreed by the two major political parties, arising from the extensive constitutional reform consultative processes over the past 25 years. And you've also said that the required legislative research has already been done. I take no issue with you because it is true that much work has been done. But it is also true that important substantive issues are yet to be settled. And these are the more difficult issues because not only government and parliamentary opposition must be on the same page, but the people. I think collectively as a nation, we need consensus on the direction we want to go in. It doesn't now exist. For example, the requirement for referendum and our own experience and the outlook on referendum makes the society gun shy. Going forward, is this a process that we need? And if yes, exactly for what? To amend the procedure, a referendum is required itself. Exactly. This issue has not been settled. The reform work will involve a thorough and comprehensive review of the Constitution, as we have to determine the extent to which the existing structure of government ought to be modified or preserved. In the same way that for very practical purposes, all that existed prior to independence could not be got rid of. And I'm not saying that people are saying we must get rid of it. We cannot now get rid of all we have. The same dilemma that we faced between the desire for change and the necessity for continuity is being faced now. We must not lose sight of the fact that Jamaica boasts a high degree of stability in its democracy, which should never, ever be taken for granted. At the same time, while it is not necessary to reconstruct our whole system of government, one problem with the Westminster system is that many of its rules and practices, the rules and practices under which it operates, do not have the force of law. Without knowledge of these rules and practices, knowledge of the legal rules alone is incomplete and sometimes misleading. These rules, principles, and practices are essential to an understanding of the relationship between what may be called the political constitution and the legal constitution, and give constitutional meaning to apparently disparate events. The pragmatic approach that predominated at independence avoided the difficult task of stating the shared political beliefs and assumptions on which the system of government depended. Many informal practices and understandings are observed between the main parties in the House. In this House we have two, and between the front bench and the back benches. Such practices are not contained in the House's standing orders, but they directly impact parliamentary business. While it may be unnecessary to reduce all of them into writing, the fact is we do have a written constitution, unlike Whitehall, and some things are not adequately provided for. The simple truth is that we must radically alter the way Parliament works, and must therefore determine what new pace will be set by the Constitution itself. Laws are to be passed for peace, order, and good government. We in Jamaica have been generally reactionary in our approach. Most of our laws are passed in response to some bi- or multilateral conditionality, as a condition precedent to getting funding or to avoid sanctions. Where laws require state agencies to report or be accountable to the Parliament, their reports must be read and interrogated by the Parliament. No, it is primarily when the news reports on something that there is a scramble to respond. In the past, agencies of government go for many years without submitting any annual report, and there is no evaluation of the effectiveness of those agencies, and the people suffer as a result. And in fact, MPs are required to take on functions that are properly and legally vested in other agents of the state. I am not saying that a constitutional solution is required to address these problems, but one may be required. For example, in how we provide for accountability in the political directorate, as well as in the civil and public services. After all, we subscribe to the principle of constitutional supremacy, not parliamentary supremacy. So we must therefore reassess the constitutional parameters. In signaling an answer, Leader of the Opposition, to why we must look back at the Charter, I pray in the very wise words of the Right Honourable Norman Manley, when he called for careful re-examination of the rights clauses of the initial Bill of Rights at Chapter 3. This is what he said: if you are not careful, you may write yourself out of the right to do many things which are useful and good for the community. Look at the proceedings of the House of Representatives on Tuesday, January 23, 1962, at page 722. Madam Speaker, I maintain that responsibility guarantees rights. To deal with the criminal terrorists that are sucking the life out of our society. And who know their rights better than their wrongs. Lord knows, we need to be wiser than Solomon, stronger than Samson, and more patient than Job to deal with them. Madam Speaker, I'm about to close. Until we achieve this important constitutional reform goal, the executive authority of Jamaica remains vested in Her Majesty and is exercised on her behalf by the Governor General. As such, I should also like to use the opportunity to add our congratulations to Her Majesty Queen Elizabeth II, our sovereign for the time being, on the occasion of her Diamond Jubilee, marking her 70 years of reign. Having said that, I must also say to anyone who is in doubt, we are making the change. We are making the change. Although we can agree that Queen Elizabeth II has always comported herself with the dignity befitting her office and status, thereby endearing herself to many the world over, we can also agree that the legacy of colonialism and slavery bequeathed to us by the British monarchy still impacts us. The persistence of both overt and subtle discrimination against people on the basis of class and color continues to influence our society and the world over in the forms of disparity in education, in health, wealth, income, social mobility, and almost any other metric we might use to measure equality. Madam Speaker, in the 6 decades of independence, Jamaica has made much progress, but we have much work still to do. Our recent progress must not obscure the reality of our past or the continuing effects of the past on the present. Therefore, in this year of Jamaica's Diamond Jubilee and that of our Sovereign Lady the Queen's Platinum Jubilee, we say with due respect, but without apology, or in the words of our own renowned constitutional law expert, Dr. the Honorable Lloyd Barnett, the historical essence of a monarchy as a form of government is rule by one person. An important characteristic of monarchism is the obeisance and adulation and submission that it demands of its subject. This relationship is enhanced by the dynastic nature of the monarchy, by which there is succession of rulers of the same line or family. The sovereign being selected on a hereditary basis and not by virtue of his or her qualities, had to claim some dynamical powers exclusively and divinely bestowed. In return for the allegiance of their subjects, the monarch had the responsibility of defending the people against external enemies and criminal violence. The monarch thus came to be the embodiment of the national spirit and the symbol of patriotic pride. The majority of colonial people and the inhabitants of Jamaica were not subjects of this imperialism, but through the slave trade and slavery were its oppressed objects. Whereas, therefore, the monarchy can truly be representative of the Englishman's pride in history of his country and may symbolize British national aspirations, unity and continuity, it cannot have the same significance for the majority of Jamaicans. In the event of death or abdication of the present Queen, Charles, or anyone who, according to the hereditary principles of English law, succeeds her, immediately becomes our king or queen and head of state, without Jamaica having any say in the matter. This is highly undesirable and inappropriate. There are many steps to be taken between now and the tabling of a new constitution. I will advise when the committee is fully constituted. I will have discussions with the leader of the opposition, and I will keep everyone up to date on all progress made. It is my intention, in leading the process, to work assiduously to place something before the Parliament, unless, of course, something more pressing happens to overtake for the start of the next session. And session is defined in the Constitution to mean in relation to a house, the sitting of that house when it first meets after the prorogation of Parliament. Madam Speaker, so there it is. The work is to get it in time for the next session so that the steps can be taken in time for the next general election. We can get to there. So I will, yes, the work between now, the next session would start at the start of the year. It's when the Parliament opens. Yes, yes. So it's the start of the legislative year, right? Because there are certain rules around what is done within the session of Parliament and what goes between sessions. And there is much to be done and how we will do it. But those will not be set out here in this presentation. So, Madam, in closing, I want to thank God for His grace and His mercies. Madam Speaker, I want to thank God. And I am confident that He who began this work in me is faithful to bring it to completion. May our eternal Father continue to bless our land and guard us with His mighty hand. And Member Jackson, through you, Madam Speaker, it's metaphorically speaking, I know my limitations, but you know they also say, metaphorically speaking, of course. Madam Speaker, I thank you.